Hey guys, good morning. Let's talk about some career things and maybe some areas where I could give you not legal advice, but just general advice. Maybe you've been thinking about the exciting career of being a criminal, and there's a lot of upside to that, right? Especially in today's modern times with schedules and things like that and inflation and stuff. And some of the benefits of being a criminal are you're kind of immune from inflation because you're procuring your cost, your items and stuff at no additional cost. There's no inventory cost. And that's nice. You can set your own schedule. You work when you want. You go to the places you want, and you can work from home. It might not be your home, it might be somebody else's home when they're not there, but still, it's a nice environment. There's no cubicle for you. But I know what you're saying. This is too good to be true. There has to be a catch. Yeah, one of those is maybe you might go to jail, but the other one is also annoying. How about the high cost of legal defense? That's not immune from inflation. So, is it even worth getting out of bed in the morning to go stalk and case somebody's house and steal all their stuff? Just if you're arrested, you have to give that money to some greedy defense lawyer. It's very discouraging. You might have to burgle 3 or 4 houses to break even. Well, there's some good news on that front, and that's what we're going to go over, which is counsel for indigent people. Now, some people are just loaded with money. Let's make this a little bigger here. It's just loaded to the gill. So, paying for a defense lawyer is no concern with these people. I'm talking about this guy. He just wants to look that way. But you have a right to an attorney, whether you can afford it or not. Under the Sixth Amendment, you have a right to counsel if you're in a criminal proceeding. And that's going to cover felonies and serious misdemeanors, the kind where you could face jail time. It kicks in when judicial proceedings have been initiated against you. And you have a right to an effective counsel, the Supreme Court says. And that's a two-pronged test. The first is the lawyer you have can't be making errors that really violate the prevailing professional norms. They don't have to be perfect, but you see what I'm saying. And then prejudice. Okay, so they made a big mistake. Did it affect the outcome of the trial? So you've got a right to make sure you have a lawyer at least doing the basic job for you correctly. So that's good news. And if you're broke, then you don't have to hire your lawyer. One will be appointed for you. Now, is this going to be an Amazon good lawyer, or is this going to be the Wish version? And that just depends. Sometimes public defenders get a bad rap, often because their heavy caseload can prevent them from spending a lot of time on a case. And plus, they're being paid for by the state. So how much time and quality are you really going to get there? Well, there are a lot of talented defense lawyers who operate under that. So I don't buy into the theory that they're all terrible or something like that, or it's rigged or whatever. But I do agree that sometimes they can be resource constrained, especially on less serious kinds of cases where they get such a high caseload. It's only so much time you can spend on it. But not everybody is special, and not everybody can have the best things in life. That's why those are the best things. What you can get is the average things, which, let's face it, if you're broke, that should be right up your alley anyway. Now, who decides? Okay, who decides whether you get a free lawyer or not? In the federal court, the judge or magistrate makes the decision, and it's probably what you would think. Yeah, there's guys in it. Now, I don't know that he's doing. He could be any appointed or defense work at the trial level now, because I know he's specializing in appeals. But obviously, yeah, he's a super bright guy, right? And so that's my point. There are a lot of very talented people in that field. So in federal court, the judge does it. And I think if you were just guessing at the system, you'd think that's how it is. But in Florida, for an example, the clerk does it. So the clerk makes the initial decision. Now, if they deny it, you can have it reviewed, but you'll see that when we go into the examples here. In Wisconsin, the public defender's office makes the decision that you get indigent status for counsel. So that's interesting, isn't it? Now, here's the federal rule. And if you look on the screen here, I've got the financial affidavit that you have to fill out if you're facing a charge in a federal court and you want a lawyer. It's not exactly a mortgage application, is it? It's pretty simple, and that's how it is most places. It's a pretty basic inquiry they do. In federal court, the rule is not that you're indigent, but the actual words are you're financially unable to obtain counsel. And they consider your dependent needs, the cost of pretrial release, if you've got to bond yourself out or whatever, how your assets are encumbered, if you have any assets, the likely cost of counsel to defend you, and they don't consider your family's resources. What do you get if you get this free lawyer in federal court? Well, you get the lawyer, you get investigative cost, And then you get experts and other things that might be necessary for what they call an adequate representation. This isn't a 5-star scenario here. This is adequate. So there's no blank check given by the government for you to just have everything that you ever wanted in a criminal defense, that the finest experts that the world has ever known will all be flown in and stay at resorts while they team together to figure out how to get you out of jail is not the standard. And it covers, like I said, felonies, class A misdemeanors, probation violation, because you could go back to jail for that. And there's a federal public defender's office, and then they also appoint private counsel. In Florida, what's the rule? So if you look at the bottom part of this, you see the statute, which says that an applicant who is a minor or an adult tax-dependent person, including an applicant who is a minor or adult tax-dependent person, is indigent if their income is equal to or below 200% of the federal poverty guidelines. And that's not, they can still be found indigent otherwise, but there's an actual kind of a bright line test there. And then they have, if you have equity in something, you're supposed to sell off what you have and use that money to defend yourself. So if you don't have much income or money in the bank, but you have assets, they expect you to use those quite naturally. This is Sarah Boone's application for appointed counsel, saying she's indigent. And you can see, I think she declared $1,000 a month of income there, I think, coming from her husband. Don't call that phone number that's on there. And down at the bottom, you see clerk's determination, right? So there it is at the bottom. Clerk says, yeah, she's indigent. Based on what I see here, I'm appointing the public defender's office. So that's what it takes for that. So again, it's not a mortgage application where it goes off to a team of underwriters who determine whether you're actually broke or not. They're assessing this on the face of it. Now that can be challenged in both directions later on, just all depending. But since it's a constitutional right to counsel, they should bend over backwards that if you're saying you're broke and what you put on the form meets that, you're initially certainly going to get a lawyer, right? Now in Florida, even though the clerk decides, okay, you're broke, you get public defense, the judge decides on experts and costs. They call it due process cost. We'll hit that a little bit later. And what you're going to get is you get somebody from the public defender's office, private counsel, maybe somebody even specially appointed. We went through Sarah Boone's list the other day of how she's been through 6 lawyers, but out of that, only one so far has left her case from an actual conflict with her, from working with her. Although if you saw the breaking news this morning, you know that the 6th lawyer has filed his second motion to withdraw. And this time he says he's pretty tired of it. And she should just go pro se, because no lawyer will ever make her happy unless they have no other clients and spend all day, every day on her case. No lawyer can satisfy her. He can't stand it anymore. Please let him out of the case. So we'll see how that goes. This is the second motion to withdraw in her case. And the first one, when he filed it, they met in court. And I think that got worked out. And the court notes said that she didn't ask for the lawyer to leave then. So the judge probably moved over some issues in communication, but they have arisen again, not just on her side of repeatedly writing these letters, bashing the guy, but now he's saying, just let me out of this case then. So will she go pro se? Will she ask for lawyer number 7? Will the judge let this guy out? That all remains to be seen. But some of the travails of this kind of thing, her first lawyer, was pro bono. So in Florida, she was only declared indigent for cost at that point, or was declared indigent for cost so that she could get experts and things. In Wisconsin, and I'm raising that one up because, of course, you see a lot of cases coming out of Wisconsin because they televise them all the time. You're eligible if the anticipated cost of counsel exceeds your family assets deemed available and family income deemed available. And that's what exceeds 115% of the federal poverty guidelines. They consider your spouse to be part of that unless the spouse is an alleged victim. And if you're a minor, they can capture funds from parents. And the public defender's office makes the determination. So the point of talking about all this is you can see from this that depending on what state you're on or whether you're in federal court or not, this right to counsel is determined in totally different ways. The clerk, the judge, the public defender's office, and what you get depends on the state you're in, whether it's a public defender, somebody who's private counsel as a contract, or just a lawyer who gets appointed onto the case. It's a big country, and there are lots of ways these things can happen, but they all fall under the general rule that you're entitled to counsel if you can't afford one. Now, what do you get, though? You get the basic tools of an adequate defense. And that makes sense, right? I know some people are like, but this rich person got more than I did. Okay. even if you think that's fundamentally unfair, that the rich person could afford the better lawyer, that doesn't mean that everybody can have the best lawyer. Everybody can't have the best everything. That's just not how the planet works. So the idea is the basic tools of an adequate defense is what you get. Now, of course, it came up in a case that, hey, but we need an expert testimony to support an insanity defense or something like that. Okay, well, you get the free lawyer. Where does it say in the Constitution that you get free experts, right? So that comes kind of under the due process clause, and that law has evolved, and in some areas is still evolving, even though we've been around for quite a long time as a nation. A lot of law is still to some degree in flux. So the original case that went up to the Supreme Court, they said, look, if it's critical to an important defense issue, in this case, insanity, then the person has a right to an expert in that case. So then it went all over the country with cases raging around, well, what does that really mean? And does that apply to other kinds of experts? And how could it not apply to other kinds of experts if it applied to this kind of expert? And expert testimony, though, must be shown to be needed on a matter likely to be significant as a factor at the trial. So you can't just say, well, I just want 20 experts. I want every field covered, Your Honor, at public expense. I want a team of experts assembled in a hotel. I want to blank off the whole floor. I want everything I want. This all costs a lot of money, so you're going to need to make a showing. Florida calls it due process cost, and they say those needed to provide meaningful access to courts. And again, if you go back and look at or if you did watch the Sarah Boone stream that we did where we looked through the history of all our experts, you see it actually functioning there, where the defense counsel goes to the court and says, I need this crime scene investigator, or I need a cell phone expert or whatever. And the court generally grants a certain amount of money for that under the rates they have and things like that. And if you need more, you come back and you tell the judge, I need this or that. And pretty generous in her case. She got a lot of different types of experts appointed in her case. And yet, of course, she wants to continue to get more. Will she get more? I don't know about that. I mean, how many psychiatrists is she entitled to have appointed until she finally gets what she wants out of it? So I don't know the answer to that. Let me look at a couple of the state also does not have a blank check to prosecute. And I would wager that in the case of, so the comment is the state has a blank check to prosecute. Certainly the government can have substantial resources, and when it wants to, more than a defense can have. However, anybody who's been on the victim side can understand that there is a limit to that. And in a Sarah Boone case, I mean, she's had, 10 experts appointed, probably more than the state has used. So I don't think that has been unbalanced. The problem she's got in her case is she put the guy in the case and then videotaped herself mocking him. So, I mean, how much money do you have to pay somebody to try and tell a story where that is okay to do? I had a federal public defender in one time in Virginia. He was awesome. It's definitely hit or miss. Yeah, that's true, right? And there are some garbage prosecutors too, of course. But if you're on the defense side, if your lawyer's bad, that matters a whole lot to you, as it certainly should, I think, in that case. So I don't think there are really too many blank checks in the system anywhere because there are budgets and stuff like that. At least that's not my experience. Having said that, it is often the case that that if the state takes a case seriously, it can put a lot of resources to something when it wants to. What happens to bond money paid, and where does it go, and do you get it back? Well, yeah, you can get it back if you're found not guilty, or in certain conditions, and sometimes it's forfeited if you violate conditions and you're found guilty. All the states do that differently too, right? Wisconsin doesn't let you have a kind of a bail bondsman like we do in North Carolina, where you can put up 10% if the person thinks you're otherwise creditworthy, and they will put up the whole amount of the bond, and you can get out of jail or whatever. So it's different in the states that different states that you go to. Let's see. What have we got? Any questions on this? Can the judge put a stop to her antics? And this is talking about the Sarah Boone case. I feel like, I guess I'm going to say that the antics part of it has been slightly overblown, because like I say, she had the first lawyer who did a lot of work for a couple of years and then withdrew out of the case because of a conflict with her. That was the actual one lawyer who has withdrawn so far for arguing with her. And then there was a series of lawyers that had witness style conflicts. And then she got the one that she's got. So in terms of writing letters to the court about this concern or that, I don't think the judge should tell her never write to the court about anything you think is a due process violation again. And, the case is scheduled, and she's the one sitting in jail, so that doesn't help her a whole lot. She wanted one more expert. The court seems to be entertaining that. Whether he's going to allow it or not is not yet known. But of course, in the meantime, now we get this motion to withdraw. So what happens at this point if the judge may smooth it over, and he already said that they're not going to try the case in October, and in that case, it would get set for trial sometime. I still think likely next year. She could go pro se and say, well, I said, I'm done with lawyers. If this guy leaves, Your Honor, I want to do it myself. And she's got a constitutional right to do that unless she's somehow disqualified from that. And being annoying is not a disqualification. Or she could get the seventh lawyer. That's what I've been waiting on, is when does she get this seventh lawyer? And then when that lawyer comes in, is he going to be able to be ready for trial in January or February, or going to want more time that she would want to consent to if the lawyer says I need it or whatever? So hard to say what's going to happen there. All right. So that's the whole story here about indigent counsel. There's a lot of depends in it because every state can do it the way they want to, but you're entitled to a lawyer if you're facing jail time, and some standard for that and determination of it and who does it and et cetera. So I didn't intend for this to be a long stream, but I thought if I try and answer this in a comment where somebody asked that, there's just a little bit more to it than that. And all right. So let's see. So tomorrow I've got the member live stream where we're going to go over a felony murder and some things about that, and what's the difference between a felony and a misdemeanor and an infraction. And here are some examples of other member streams we've done where we vote on the topic, and then I did a video on it to address whatever questions people have. But then Friday, we'll do the weekly docket, and we'll get into Sarah's stuff a little more, and also some stuff on Alexi Treviso, because she had a motion yesterday and the judge made some rulings and reserved some more that are quite significant in her case. We'll look at her potential defenses people have raised up, and then we'll look at what's really going on in the Brian Kohberger motions and what are the real results of that, and what are the potential results for the things the judge hasn't ruled on yet, and try and clear away a little bit of smoke out of that. Where the prosecution is the punishment. Yeah, I hear that part. The old, you can beat the rat, but you can't beat the ride. And there can be certainly, whether it's political or not political, right? But certainly it's terrible when it's political, that using the state's power against people can be its own form of punishment in terms of destroying your life as you know it. If you're somebody who doesn't deserve to be prosecuted, bankrupting your reputation and all those things. So I definitely hear you on that and agree with that. And of course, the Bill of Rights was meant to, as much as it could, try and check those things through the use of a grand jury, through appointment of counsel, through the limitation of the whole Bill of Rights is about limiting the government, and not this new twisted kind of logic of where, well, actually the Bill of Rights is there to make sure the government has more power. It's not in any of the Bill of Rights. That is not the point of the Bill of Rights. And a lot of it was featured, the Bill of Rights centered on criminal prosecution, because that is, as you're pointing out here, even though I disagree with you slightly on the blank check part of the state side, I do agree with you that the state has the resources to bring a case when it wants to. And when a state brings a case when it shouldn't, it's abusing its power. And as an individual citizen, it's very hard to stand up against that, whether you've been rightly or wrongfully accused. But certainly when you're wrongfully accused, that's a terrible injustice, because they're spending public money to come after you. So yeah, that's what the whole Bill of Rights is for, right? Is to say, hey, we're going to add additional protections to citizens from the power of the government. And sometimes it works, and then sometimes it doesn't work. Yeah, there's in terms of Sarah getting her case closed, it could go pro se because she has that talent of being able to close a case. And however, she's now the one stuck in a case, and I think there's a bit of karma for there. They would never get Sarah to go to trial. Maybe she keeps claiming she wants to, right? But yet she keeps needing more experts and more time and stuff like that. And now she's going to have to deal with coming to court and discussing with the judge her attorney's second motion to withdraw. And I have to say, he seems pretty emphatic in this one, doesn't he? Saying that she'll never be satisfied with anybody. She only wants a lawyer who's just going to work on her case all the time, and she'd be better off going pro se. If you're her, do you want this lawyer to keep representing you because you clearly aren't getting along with him? She has said all of that, and now you hear from him. This street has two-way traffic on it. And if she gets another lawyer, the case is going to get delayed anyway past October. So like I say, I think it goes into next year regardless. But if she gets another lawyer, does that introduce a larger delay than if she resolves this motion to withdraw or goes herself? You're going to have to see what happens on that. But there's more insanity to come in that case, that's for sure. At what point does she plead for time served? Yeah, and that's a good point. I don't know that they've offered her a plea yet, right? And maybe they haven't, maybe they haven't. I don't have any idea. But still, I agree with you here in that I think she's got a lot of time in there. And if the state at any point wanted to back off of second-degree murder to a lower count where her sentence range would be at or within a couple of few years of time that she's already got in, she'd be crazy not to take the plea because she could face a significant, potentially life sentence if she's convicted of second-degree murder. So the gambling part of this would tilt toward if she can see reality, she should understand there's a real risk of being convicted of what she's charged for. And if she's offered a better deal than that and she already has time in the bank to apply against it, which her time served would count for that, then I would say she should definitely consider it. And if the state isn't bringing that up to her, then her side could bring it up to the state. But do you think that's really happening right now? It looks like they were prepping for trial, and plus her attorney was in a capital case. So I don't know about that. And I don't know anybody could talk her into it anyway. But it's a good point. And if she gets offered the plea, she should consider taking it. And good morning to Judy. Hope everything's going well with you. Battered spouse won't work. Better off pleading battered fish. Yeah, so when we did that stream where we went back through her, and this is turning into the Sarah Boone stream, but when we looked through all the experts she's had in the case, it became clear to me then that she's had this battered spouse thing in mind for a much longer time than I had thought. So it was illuminating to go back through the docket, as it sometimes can be. It's terrible for the victim's family. Yeah, I mean, it pretty much is bad. On the other hand, if you're her family, you're like, well, she's in prison, all right? So hypothetically, she could go to trial and, depending on what happens or whatever, I don't think so, but she could be found not guilty and then she's out of prison. So if you're the victim's family, you should take some solace in and you think she's guilty, that she is at least sitting in jail right now. But the repeated delays and things are bad. On the other hand, if you are them and you read just how frustrated she is and how she thinks she's unfairly locked up and being delayed, you might not think that's the worst thing for her to have to go against. It's not against the law to be stupid. Generally not, although no, I don't think they could. They just had to put a fence around the country at that point, and you may catch a few innocents in there, but there are big parts where that's fortunate that it's not the case. Are stupid or uninformed. Now, remember, if she does want to represent herself, she has a right to do it, and they can't put her through a law test and say, tell me the exceptions to the hearsay rule. Tell me how you would admit this exhibit. Tell me what the law is on, this, that, or the other. Tell me the elements of an affirmative defense. You can't put them through a mini bar exam. That's not the test you're allowed to do to exercise a constitutional right. What the judge will do is go through the whole speech about, in theory, I haven't looked at the process in Florida, but they should make sure the person understands and appreciates the risk of going pro se versus having a lawyer, and that they can capture that in their mind. Not that they're good at what they're going to do if they go to trial themselves or know what they're doing when they get there, but just that they understand what they're going into. That's all the judge is supposed to do and really can do. And that's what the judge did in Darrell Brooks' case originally. And that's what will likely happen again if he's going to be moving pro se in September, which could be coming up. I appreciate this trophy. I can't see if it's first, second, or third place and how many contenders were involved in it, but thank you. I'm going to assume the best. So that's it for indigent stuff. That's pretty short, and we talked a lot about Sarah Boone instead. And so if I don't see you tomorrow, I'll catch you on Friday for the weekly docket, which this week is stacking up with some things, like I said, with Alexi Treviso and the murdered baby case. Koberger with some very interesting legal contentions on both sides of that case. The Boone drama continues, and there's a couple of others. Right here. Well, I will talk to you guys later. Have a good day.